Okay, so this part of the presentation is going to be related to some of the guidance that's come out from the Department of Education related to COVID. And it was tricky because when all the schools closed down, I think it was like March 13th, nobody knew what to do, right? It was an unprecedented time. We had no idea what we were working with. We didn't even know how long things would be closed down. So I think as time went on, the Department of Education determined what this should look like for students. And then we had SB 98 come out that further defined what's required of school districts during COVID. Now, because this is a new issue and we don't have a lot of hearing decisions or even appeals to higher courts on COVID-19 cases and whether the district's complying with the IEP process or IDEA or not, it's sort of difficult to explain how it could play out. What we do have is some hearing decisions that tell us that the judges are finding, no matter how hard the district is trying, if they're not complying with what's listed in the IEP, they're finding the districts out of compliance. And that they have to provide compensatory education. So I think maybe what we've determined as attorneys for families or students is that it might be worth it to file a compliance complaint first. Those are coming back successful, and then using those in a hearing to get your compensatory education that you want if you're not able to get it through the compliance complaint process. Anytime you involve a judge, it's gonna, you don't know, there's no guarantee, right? You just don't know what's gonna happen. And I think we're all trying to figure out how this is gonna work. I think there are times where the district is trying their best to comply, but with the rules in place for like the health code and stuff, it's difficult for them. But there was also, instead of feeling bad, you should understand there's funding that was put in place from SB 98 to help these districts provide compensatory education where they think the student might have regressed because they didn't get all the services that were listed in their IEP. And there's a requirement that this be listed or discussed at these IEPs. So we'll get into that, but I think for all of us, we're not quite sure yet how it's all going to play out. What's really important to know is that in March, when everything closed down, there were waivers, and I don't know if parents have been given updated information, but there was a waiver about in-person assessments and when those had to be completed. It was a waiver on timelines, basically. There was a waiver on education records and how quickly the district had to get the records. Usually it's a 5-day timeline, but there was a waiver on that, and I think it was waived it to 45 days, which is the federal requirement, not the California one. And so those timeline waivers were to assist because there was nobody at work. There was nobody at the districts, right? But and we were all sort of sitting on the edge of our seat waiting to see if there were going to be any waivers related to what had to be provided to students with disabilities. And what came from that was that our government determined that there should be no waiver, that the people who have IEPs are entitled to what's written in their IEPs. And if there's an emergency, the team should come up with an emergency plan on how the IEP is going to be implemented, and this should be done now in advance. I think the deadline is like June 2021, maybe. It might be 2020. It's in one of my slides. The teams should be determining if there's another emergency and the schools are closed again, or let's say we have a hurricane or something. It's an emergency is like generally defined, but they want these teams to be coming up with what this looks like for these students if another emergency arises. But right now, what's really important to know is that there are no waivers on any of the IDEA requirements. In fact, there are additional things that have to be done by the school districts now because of COVID and because of SB 98. So we'll get into those. The local educational agencies are permitted to offer in-person supports and services. Now, I think that's really important because even in March, when there were some waivers that came out, that the LEAs were allowed to continue to do some in-person services, but some of them refused to. So there were a couple situations that I had actually with clients where there was like an outside agency providing speech. Well, speech was determined to be an essential service, and it was in a speech therapy office. The person was already going there and not getting it at the school setting, and the district was already funding it. This district said, no, we're not doing any in-person services. We're not paying for this. Even though the speech provider had put all these precautions in place and had determined they were an essential service, this district said, no, we're not doing it. And what's really important to understand is there was never a waiver on that. Yeah, there were rules that came out about how many people in a classroom and what precautions you had to take, and that the schools had to close, but it didn't mean the schools couldn't fund in-person services somewhere else. It just meant that they couldn't attend the school setting. So that's important to remember, especially if you believe your child has had some regression because of being out of school and not getting any of those in-person services. I gave you a couple websites because I think it's really important. Again, knowledge is power, right? So you guys need to be reviewing these publications that are coming out on the California Department of Ed, and they really are parent friendly. Like their question and answer, I have some of the stuff in my slides is pulled directly from their publication because it is so parent friendly. And it's question and answer, like I said. So there's a question, which might be a question you've had, and then California Department of Ed tries to answer that. So there is a web page dedicated to this guidance and the resources for teachers and families related to high quality distance learning. So since March, a lot of the school districts and CDE have determined, or they've sort of tweaked things and messed with things and figured out how they could be providing high quality distance learning even if these students can't go in person. And I think they've come up with some really great options. What's important to remember is you always have to look at what your child needs in comparison to some of these suggestions. These are just suggestions. It doesn't mean every student needs what's listed, but I gave you the link here, which will take you to the page that talks about COVID, and there are updates that they put on there. I think the last update was November 12th, maybe, but it didn't have anything to do with any changes to the COVID laws. It just was talking about other education items. They have also developed a frequently asked questions page, and it talks about all sorts of things like instructional time, how they're counting attendance. SB 98 also said that they have to start tracking someone's attendance, and there has to be a level of in or direct instruction, not in person, but direct, meaning the teacher has to have camera time and a certain amount of it with every student. So that's pretty big too. And it didn't say like, oh, you have to have 5 hours a day or 3 hours a day or whatever, but you had to have some direct instruction time. So one of the questions that people ask are there new requirements related to the IEPs and distance learning? The answer is yes. The answer to whether there's a waiver is no. The answer to are there new rules is yes. And it actually, I think, added protections more than making requirements of things. The attendance thing is a requirement, but it's not defined how much direct instruction, how much time is considered direct instruction. So again, there's flexibility. So on June 29th, Governor Newsom signed the 2020 Budget Act and accompanying budget implementing legislation, which in that was SB 98 or Senate Bill 98. This SB 98 included some notable changes related to special ed and distance learning. The CDE posted the guidance on their website, and I give you the link to it. Again, I think it's parent friendly the way that it's listed. It did amend section 56345 of the Ed Code, and it requires that IEPs now include a description of means by which it will be provided under emergency conditions. So in which instruction or services or both cannot be provided to a pupil either at school or in person for more than 10 school days. So this doesn't mean so some of the schools have gone into cohorts, and if somebody in the cohort has COVID, they have to go home for 14 days, just that cohort. They're not closing the entire school down, they're closing that group down. They have to go home for 14 days. That doesn't necessarily mean this gets triggered unless they're not able to provide in-person services for more than 10 school days. If you have to be home for 14 days and they're not going to allow a behaviorist to come in or speech services to come in, then this would be triggered. And I think the reason this was added to SB 98 is so that we're making decisions prior to any emergency, right? And so some of the districts have actually come up with a form. They call it like the SB 98 form, and it asks all these questions, and that's being attached to the IEP. One of the things I'm telling my families is to list your best case scenario for distance learning. What would that look like, right? Are their parents home? If parents are not home, how do we make this happen? And so it should be individualized to the student, but also what that family dynamic looks like. And it's required now. Like, it wasn't required before, but it is required now. So this description should be included in each initial IEP. So if somebody's getting their first IEP, or any regularly scheduled revision, which could be like an annual IEP, or maybe you're doing a progress reporting IEP. And the requirement is, I think the timeline is 20, it says it here somewhere. I think it's June 2021, but it'll come up on the side. Another question asked frequently: do the requirements for distance learning and instructional minutes for the 2020 and 2021 school year, which is what we're in right now, will that impact the specialized academic instruction on a student's IEP? And the short answer is no, it shouldn't. Distance learning should not change what was determined by the team to be that student's needs. So that is why SB 98 said you should have this other plan, but that doesn't take the place of the actual IEP. So IEPs are supposed to be still developed like it's going to be a brick and mortar setting, right? We're supposed to be thinking about what does a student need if they were at school every day, and then you develop your SB 98 plan based off of what it looks like if they're in distance learning. And again, that SB 98 plan is not your stay put. It doesn't take the place of your IEP that was developed. So CDE also outlines out what is an emergency condition. So again, there's a definition of what counts as an emergency, but you have to remember that when this is triggered is if the district believes you're not going to get in-person or in-school support for 10 school days or more. So if they know for sure that your cohort's going out for 14 school days, they know you're going to miss 10 school days or more. So these plans should be in place for that period of time. One of the other things that's really important is that your team can determine that you need that plan, that SB 98 plan to be in place even before the student goes 10 days without school. So they don't have to wait for the student to miss 10 school days before they put the plan in place. They just have to know that that student's going to miss 10 school days. They can start it right away. So what's an emergency? Well, Ed Code section 46392 outlines what constitutes emergency conditions. It includes fire, flood, impassable roads, epidemic, like we have, earthquake, imminence of a major safety hazard as determined by the local law enforcement agency, a strike involving transportation services to pupils provided by a non-school entity, and an order provided for in Education Code 41422. I haven't looked that up, but my guess is that it's an order to close all the schools, like what happened in March. So those are what are considered emergency conditions where your SB 98 plan would start. Here's another question. Is the emergency condition description part of the IEP or a separate document? It's part of the IEP, but it doesn't take the place of the IEP. So there's a requirement that it be in the IEP, but it doesn't mean it's going to be your stay put if it gets implemented. And here's the date. Every school district, let's see. Yeah, this should be listed in every IEP as of July 1st, 2020, unless you're doing a revision. So like some students they knew their annual was coming up later, and so they waited, the schools waited. And I don't care, I'm not making a big deal about this. Not having the SB 98 plan is not as big of a deal to me as it is that the districts aren't providing all the IEP services that were agreed to. So if you want to delay in putting in an SB 98 plan, then you're going to owe some comp ed for all the time where they didn't get the services they needed. Must the parent or student consent to the description that's required? Yes. So as a required component of the IEP, the description of the means by which the IEP will be provided under emergency conditions must be adopted by the IEP team. So the parents, it doesn't mean the parents are forced to sign. It means the parents have to agree to it and sign it for it to be implemented. So the school district can't say, well, if you don't want to sign and you don't agree to it, we're going to implement it anyways. No, the parents still have all the rights they would have under the IEP process, which means without their signature, it cannot be implemented. So it's really important for the school district to work with the families to make sure that description is what everybody thinks it should say. Okay. So how does the IEP requirement for this description under emergency conditions impact the offer of FAPE? We talked about this a little bit. It doesn't. Will the student potentially get less services? Maybe, if it's distance learning, possibly. But it doesn't take the place of the IEP. So, and this is even more important, what happens if this description does not adequately address or anticipate the needs of the student? So IEP teams are required to meet when a student demonstrates a lack of expected progress. That's always been the case. That's not a new law. Additionally, the parent or the teacher can request an IEP meeting at any time to discuss and address any concerns with the student's access. So ineffective IEP goals, not getting enough related services, if parents see regression. The California Department of Ed says that teachers and parents are encouraged to work together to ensure that a student is able to access instruction and that the delivery of instruction is effective. The IEP can be changed or amended at any time with agreement from both the parents and the LEA. So this description of the emergency condition isn't going to change if somebody's IEP needs to be edited. Again, you have the IEP, what is supposed to be provided, and then there's this plan that can be implemented if there's an emergency situation. And what the parents should be doing is reporting if there's regression, because under SB 98, that triggers a requirement for the school district as well. Okay. So should the description of the means by which the IEP will be provided under emergency conditions include provisions for how the LEA will deliver feedback and information to parents regarding the student's learning progress during the closure? So the Education Code 56345 does not specifically require including plans for delivering feedback and information related to the student's progress. Communication and collaboration between the local education agency and the parent are vital to ensure educational progress. So even though it doesn't specifically say it's required, Department of Ed is saying, but we all know that you should be working as a team to ensure that this person is making progress. Education Code 43504 also requires that during the 2021 school year, each school shall regularly communicate with parents and guardians regarding the pupil's academic progress. So for this school year, the school districts are supposed to be communicating with the parents about what that person's progress looks like. And as a parent, if you want to be an advocate, you should also be reporting to them and making them note it in the IEP that there's been regression, because that again is going to trigger this potential requirement of comp ed. And SB 98, there was some funding that came from all of this to the school districts because they knew there were going to be some students who needed compensatory education. So you've got to explain it to your team. You've got to ask them to notate it in the IEP, and then you should be having a conversation about what that comp ed looks like. How are we going to make up for this? One of the other things that did have a waiver at one time was the special education assessments, but now they're required to continue conducting special education assessments even while they're providing distance learning. So when distance learning first started, they were not required to do in-person special education assessments. That's no longer the case. They are now required. It does say that the parents and the team should reach a mutually agreeable extension of time if it's appropriate, or be creative in the way the assessments are done. I think it all depends on how comfortable the parents are with having the student be in person doing those assessments. But those assessments are still required, so that has not been waived. And whatever waiver was in place is now removed. Again, this just asks if it can be if these assessments can be conducted in person, and yes, CDE does not expressly prohibit in-person assessments. I think also what's really important is that, again, just because schools were closed or may close again, CDE is not saying that in-person services cannot be provided. What they're saying is be creative. Think about how you best comply with this IEP, and if that takes some creative solutions, you should be doing it. Some districts are refusing to do that. They don't want to fund people coming into the home to provide ABA services or speech services. But just because they don't want to do it doesn't mean it's not required. But really in those cases, what's going to need to happen is for the parents to track the regression because the district failed or refused to provide those services, and then you're going to get your comp ed hopefully after. Anytime a district doesn't comply with an IEP doesn't automatically equate to comp ed. There's a higher standard than that. You have to show that the parents weren't able to participate, or that it was it significantly impeded the student's ability to receive an education. So it's not just you didn't comply with the IEP. You've got to show more than that. It has to be a significant non-compliance, and then that would rise to the level of getting compensatory education. Okay, so I have some additional links here for you. One of them was the April 9th special education guidance. It said any in-person services or supports should seek to comply with federal, state, local health officials' guidance related to physical distancing, with the goal of keeping students, teachers, and service providers as safe and healthy as the primary consideration. So what they said was, please do everything appropriate to keep people safe. What they didn't say is you cannot do in-person services. Districts took this guidance and still said, we're not doing it. Our schools are closed, we're not doing it. I think there's gonna be some potential cases that come from that where there's significant regression because they were allowed to fund in-person services as long as the people providing them were taking all the precautions required. But some districts chose not to. So those students who've regressed are going to be entitled to some comp ed. That's my opinion. There are probably other attorneys that don't agree with me, but that is my legal perspective on it. The California Association of School Psychologists have also developed several resources related to assessments and COVID-19. It includes considerations and recommendations for conducting in-person assessments, which I think is great. This is probably a really good resource for parents who are concerned about in-person assessments and how this is going to be done effectively or thoroughly if the person is doing it through Zoom, right? Or if you have to be 6 feet away from the person you're assessing. So I gave you guys that link as well. And this PowerPoint will be shared with you, so you can just hit right on the link and it will take you to it. Are there special education timeline waiver provisions? And no, there are not. So there were some waiver provisions, but those were temporary and they have since been removed. LEAs must adhere to all state and federal special education timelines, including those related to assessments and access to educational records. Another piece that I added, just because I think it's something we don't really talk about a lot, but it's like the social and emotional well-being of students who have been removed from their peers, their schedules all messed up. You know, most kids spend a majority of their day in a school setting. It's like their second home, and that's all been turned upside down for them. Then you have the students who require that routine, right? Some of our special needs students have a routine they're familiar with and it just gets disrupted. So there was a section on CDE's website about this, and it says, if students are unable to meaningfully engage in distance learning due to social, emotional, and/or mental health needs, what support should the LEA provide? What are the state and federal mandates? So I actually have some students who are clients of mine that attended a non-public school. So one of the more restrictive settings, pretty significant behavioral needs, would never sit still to look at a computer, and they were doing only distance learning. So what CDE says is that students with disabilities are required to have educational programs that are designed to meet their specific individual needs. That has not changed. If they cannot access the instruction or education, I'm telling parents to ask that a one-to-one aid be provided in the home. A lot of the answers we're getting from the districts is that one-to-one aid, we can't force them to come into your home. They don't feel it's safe because of COVID. We can't make them. We have employment liability issues, which could be true or could not be true. I don't know. I know nothing about employment law. It's possible, right? Maybe it's not in their contract. I don't know. But what they could do is fund a private agency to do it, a non-public agency. So in some situations, I've had districts say, okay, we will pay your ABA provider, we will contract with them. If they agree to provide a one-to-one behavior aid for the student to be able to access his Zoom meetings for school and work on some of the worksheets with him, we'll pay for 3 hours a day, 5 days a week for that person. And so some families have agreed to do that, even though that student would be getting 5 hours. They feel like it's sort of a fair compromise, and that has become that emergency plan, right? Like that's what's going to happen in the future if this student stays in distance learning. The other consideration is distance learning. Okay, some schools have reopened and parents have determined that their student, they could have health conditions, there could be somebody in the family that could have some underlying or pre-existing conditions where if somebody got COVID and brought it into the home, it could be detrimental to the household. So some parents have decided because of those medical issues that their child is gonna stay in distance learning. The district should be considering that as well. It can't be well, if your kid doesn't come back to school, then we don't have to do anything beyond that. That's not accurate. And again, they should be working as a team to come up with some creative idea, even if it's not going to give that student every single hour of what is in their IEP. The Ed Code says that distance learning includes several components, or can, which is academic and other supports designed to address the needs of pupils who are not performing at grade level or need support in other areas. Special ed and related services should be included in any other services required by a pupil's IEP. So distance learning still should have all the components of that IEP, even though they're distance learning. We know that that's not happening. I think a lot of families know, they almost feel like, that's not really fair, right? The district didn't get notice of this, just like we didn't. But since March, there's been a lot that's been developed. We are now in November. I think the district should have it figured out by this time. So if you don't feel like the student is getting what they need, they're regressing, you should call an IEP meeting before the end of the school year to discuss how it could be done differently. So one of the additional things that came from SB 98, I mean, there's lots of components to it, but I'm trying to only talk about the ones that apply and I think will apply across the board to everybody, is this attendance plan. So I talked about it a little bit, but there is this requirement that they get direct services. And again, it's not defined what that means. Some non-public schools who are closed, but were doing distance learning, and that student wasn't accessing it, they were saying just log on for the first 20 minutes at least, try to get him to sit there for the first 20 minutes so we're all complying with this direct instruction piece, and that's how we'll count his attendance for the day. And I think that's probably appropriate in some situations, but I also think it's appropriate for them to put someone in the home so he can access that. But if they're going to refuse to do that, then the next best case, I guess, is that they only require a minimal amount of time for direct instruction to count towards the attendance. If a period of time goes by and they're not getting this direct attendance, there has to be an IEP meeting held to talk about how to make sure the student is getting this direct instruction, whether they're at distance learning or not. There is a website here, and it provides educators and parents with info on how to address a student's social, emotional, and mental health needs in the home during distance learning. So just another resource for you guys. What is the LEA's responsibility to provide educationally related mental health services? Same responsibility as before. If it's in the IEP, it should be provided. If it can't be provided, with the way the IEP is written at this time, there should be a plan with the district on how it's going to be provided through distance learning. And listen, CDE knows, and they say this multiple times, that these school districts may not be able to provide all the services that are in the IEP in the same manner that they had prior to COVID, but it doesn't mean that they shouldn't try. We have to be flexible, we have to be creative, we have to think about how we do this as a team. I can tell you, like, just from the clients that I work with, a lot of them are very reasonable and are willing to sit down and compromise and sort of talk through these things. But if the district just makes decisions without them, it's very off-putting, and I get it. You should be a part of that team, and you should be able to say, this is what I think he needs or she needs to be able to even sit at a computer. And then again, we've got to take into consideration if families even want outside people in their homes, right? So there's all these considerations we have to think about when we're determining how does this work for this particular student. I have some law that's cited here for you guys that you can look at. I don't want to just read everything verbatim for you, but you'll have access to all of this. Does the LEA, we talked about this a little bit, do they need to wait 10 days before implementing the description on this SB 98 emergency plan? And the answer is no. If they think this student student or these students are going to miss 10 days or more of school time, of school days, they can implement it immediately. But again, only if it's signed by the parents. Additional information, there is a California Department of Ed memo that just talks about if schools closed, how it impacts students, what the school district should be doing. I mean, CDE has a lot of good resources right now, so if you have questions, you should go there and start looking at their publications, and then obviously write them down so when we do our question session, I can hopefully help you. And that's it. I'm sure people will have lots of questions, and we will have a question session. I'm also going to make sure this is accessible, and those sample documents I showed you, the services page, and then the other one that started with the individualized transition plan with all those other little pieces to an IEP. That sample with the ITP attached is not necessarily in any order. I just put it together because it has some components I wanted you to see. So yours may not look like that or be in that order. And then please just remember that this is my, as a lawyer, my perspective on what the COVID rules are, what the special education requirements are. There may be attorneys that think differently, and it really is going to depend. This law that I cited, it changes all the time, so please don't rely on it. You should always be looking up the current law. You should always be looking at CDE's website. Those are just things to remember, that this is not it's not black and white, right? And the laws are changing, and they're changing fast with COVID because we don't know how things are going to play out. So if you ever have questions about what I put in my PowerPoint, you will have my contact information. But always get advice if you don't understand what the current law is. And thank you for your time.